Do you want to keep a good relationship with your business partners? Well, the best way to do this is to talk about all the issues that could arise in your company before you get started, and then write down your agreed positions and thoughts in an agreement. And this is known as a shareholders agreement. Now, the on your terms shareholders agreement covers a number of things. This includes how many shares each shareholder has, how you can appoint and remove directors, what happens if the company needs more money along the way, are you all obliged to put more money in, the situations in which all of the shareholders, or at least 75% of the shareholders, need to agree before the company can take an action, such as taking on more debt, whether shareholders have to work in the business, whether shares have to be offered to other shareholders first before they can be offered to outside third-party shareholders, whether drag-along rights and tag-along rights apply, what happens if a shareholder dies, what happens if a shareholder behaves badly and the other shareholders want to kick them out, whether or not new shares being issued in the company have to be offered to existing shareholders first before they can be offered to any outside third parties, what restrictions you have in terms of whether a shareholder can compete with the business or take customers or employees when they leave. Now, we've got detailed videos on each of these topics to help you decide what will be best for your company and therefore what you need to include in your shareholders agreement. So with the shareholders agreement and constitution bundle, when you're answering the questions, you're actually creating both the shareholders agreement and the constitution at the same time. They're separate documents, and you might be wondering what the difference is between them. So the shareholders agreement sets out the rights and obligations of the shareholders, and it's really sort of the rules that apply between you and your fellow shareholders when it comes to your ownership of the company. The constitution, on the other hand, is sort of more about rules that apply to the company. Now, if you don't have a constitution, the Companies Act will apply, and sort of the default rules that are in the Companies Act will apply to your company. However, there are certain things that your company can only do if it says so in its constitution. These include buying back shares from shareholders, being able to indemnify directors or employees. So this means that if there was a claim against a director or an employee, they might have some cover from the company in relation to that claim. Also to issue directors and officers insurance. But more on the on your terms shareholders agreement. So the on your terms shareholders agreement is really designed for a small to medium-sized Kiwi company where the shareholders are all involved in the business. It's not really designed for a situation in which you have investor shareholders who aren't involved in the business, because normally different rights and obligations apply to these shareholders. For example, they might have different types or classes of shares with different voting rights attached to those shares. Or obviously they won't want things like non-compete restrictions to apply to them because they might be shareholders in a number of businesses. So if you do have investor-only shareholders, it's likely you'll want to consider making some further customizations to your shareholders agreement. And our law firm partner can help with this if you would like them to.